This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Donald Trump has started his second term with a torrent of executive orders designed to transform the government and assert sweeping presidential power. In the first of many legal fights expected to end up at the Supreme Court, the justices have decided not to decide. With a bare majority of 5 justices, the court said in an unsigned order that Hampton Dellinger, head of the Office of Special Counsel, should remain in his job at least until Wednesday. That's when a lower court order temporarily protecting him expires. So the court neither granted nor rejected the administration's request to let Trump fire Dellinger, who heads the independent U.S. agency that protects government whistleblowers. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Hal, will you explain the issue around the firing of Dellinger?
In creating offices, Congress often has protected the office holder from the plenary removal of the president and limited the president's reasons for being able to remove the officer, usually to neglect of duties or for cause. And the Office of Special Counsel, which is in charge of protecting whistleblowers against the government, is focused on trying to protect employees who complain about what's happening in their government jobs, government waste, etc. And so Congress decided in creating this special office to protect the head of it from at-will removal. And the independence Congress thought was necessary in order to protect the independence of the office, because oftentimes the Office of Special Counsel protects employees against their bosses.
Was the question here a procedural question, really, whether or not the TRO issued by the lower court judge could be appealed?
That was the narrow issue that the court decided, and the court decided it's better to wait until there was a more clearly a final order before they decide the case. The case is complicated for a number of reasons, and I think the press has missed at least one of them. I think the most obvious legal issue is the Trump administration's movement to be able to fire any individual worker or officer at will in order to maintain the unitary executive ideal. But the other issue, which is connected, is even if you can't remove someone for any reason at all, what's it like to reinstate someone against the president's will? So in other words, there might be a claim for back pay, as there was in the famous Humphrey's Executor case several generations ago, which is the lead case upholding the independence of agencies. But in that case, the court never had to force an officer, in that case, a Federal Trade Commissioner, back into office. Here, this would be the first time, or at least one of the first times, that a court would actually reinstate someone and force the president to work with someone that the president doesn't want to work with. So there's really 2 aspects of this case. One being part and parcel then of the president's ambition to be able to fire anybody at will. But the second, which is connected, is can a court force the government not only to pay back pay, but to take somebody and keep them on their job against the president's wishes?
Was the Trump administration trying to make this an issue beyond this one firing? In other words, they said that the order exemplifies a broader trend by lower courts with plaintiffs challenging Trump's initiatives and persuading district courts to issue TROs that intrude on presidential Article II powers. So were they trying to make this a bigger issue?
In part, but I think this is also more of the mosaic that one can see from the president removing one of the NLRB members, National Labor Relations Board members, one of the MSPB, which is the Merit Systems Protection Board officers. And not only that, just last week, the executive order basically declares war on independent agencies and says that there really aren't going to be independent agencies. They all have to come for guidance from the president and from OMB, Office of Management and Budget, and he's not going to respect the independence of any kind of agencies. And so the Solicitor General wrote to Senator Durbin, Judiciary Committee, and said that the administration will no longer defend administrative agencies, and indeed they're going to try to make them into what's called executive agencies or more dependent upon presidential leadership. So I think that, yes, there is an interest in the Trump administration to try to minimize the number of TROs that have been entered against his executive orders and DOJ activities. But at the same time, this is very important to the administration to try to, again, sort of conform to this unitary executive ideal, which says Congress can have no say in making an office independent. Every office has to be totally dependent upon presidential will.
So the court decided not to decide, and it was basically the middle of the court, the Chief Justice and Justices Elena Kagan, Brett Kavanaugh, and Amy Coney Barrett. But surprise, surprise, Clarence Thomas, one of the most conservative justices, joined them to make the fifth vote.
So I'm very surprised about Justice Thomas because Justice Thomas has been on record as expressing skepticism about the independent agencies in the past. So I don't know what accounts for his. Maybe he also believes and it's important to have final court action before any kind of appeal to the Supreme Court. That may be the basis of his agreement to join the middle in this particular issue. But it's a very narrow decision. All it's saying is let's wait until there's a final decision. That may come as soon as this week. And so the issue may yet again return to the Supreme Court in due course.
You had the two most liberal justices, Sonia Sotomayor and Ketanji Brown Jackson, saying that they would have turned the president down. And then you had two justices, Neil Gorsuch and Samuel Alito, considered two of the most conservative, saying they would have granted Trump's request. Gorsuch wrote a dissent. Did it support the unitary executive theory?
It's a signal that he would support that, and that would be consistent with, I think, his ideology as well as that of Justice Alito. And it's no surprise, given the recent decisions by the Supreme Court in both the Sell Law case and in the Collins case, that the writing has been on the wall with respect to the ability of independent agencies to continue. So I think their views are not surprising, but it's not clear yet. If I had a bet, I would bet that the court was leaning towards overruling Humphrey's executor and getting rid of so-called independent agencies, but that's not a for sure thing. And it may be that some of the conservative justices are taking a deep breath and saying maybe we should hold the line because they are looking around them and concerned about what the unitary executive might bring to the country.
In his papers, Dellinger did warn that you're going to be overwhelmed by Trump filings and a rocket docket straight to the court. And in his first administration, he sometimes skipped over the appellate courts and went straight to the Supreme Court. So could this set a precedent?
Sure. If the court decides to hear this next week without having a full appellate process, then this would be a signal that the court is willing to bend its rules and to take cases quickly in order to figure out whether or not to uphold President Trump's agenda. I don't think the court would like that. I think the court usually wants to benefit from percolation and from getting the benefit of individual judges' opinions below. And this isn't like a huge national security case. It has to do just with, again, a narrow question of presidential removal authority. But who knows? Maybe they want to take this case, and maybe they will, and try to expedite the case on the docket.
Recent Supreme Court decisions, don't they suggest that Congress can't interfere with the president's power to remove subordinates? I mean, didn't we see that in the CFPB case?
And what was very striking was in Chief Justice Roberts' opinion in the immunity case. He talked about the removal power as one of these core executive powers that Congress could not interfere with, suggesting that for-cause protections might be unconstitutional, as indeed he ruled in the CFPB case that you mentioned. It's possible. It's possible that they believe it. And what is striking is they've never really articulated why Congress can't have any kind of say in creating an office, whether that office should be somewhat independent, as in the special counsel case, because the special counsel is protecting whistleblowers. And when there is this perceived conflict of interest within the executive branch, isn't independence an option that Congress can try to establish if it thinks it's appropriate for the country? And the court just blinks at that and says, Article 2 executive power, Article 2 executive power, and they've given no credit to Congress's interest in this case.
I'm wondering if they're going to try to walk that immunity decision back a bit. It was hastily written, and as I believe you and certainly other people have said, it was not the most reasoned decision.
It was not the most reasoned decision. I think it's not directly relevant to the question of removal authority, but certainly there are seeds of the fact that you need to protect the president when the president wants to fire someone in that decision. And again, it's all possible, no one's discussed this yet, that the court may try to split it by saying, we won't reinstate because that would trench upon presidential prerogatives, but we will say it's an unconstitutional action and back pay has to be awarded. And so that's at least a signal that if the Trump administration wants to fire all these people, they're going to have to come up with the money somehow because they violated the congressional restriction.
When the cases of all the federal employees being fired and the agencies being shuttered except in name only get to the court, how do you think they'll rule?
It's clear that President Trump believes the Civil Service Act is unconstitutional. So I do think that a case or a variant of it will get to the Supreme Court. And I think the Supreme Court's going to have a hard time saying, given all that Pendleton Act and all the history of 125 years of the civil service, that's just going to go up in smoke. I think they'll say that the president has to have some control over policymakers, and I think that's a line that's at least far more defensible, depending on how you interpret it, than the idea that the entire civil service is unconstitutional. But that's just my prediction. One can never judge.
So we try to. Thanks, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. Coming up next, changes ahead in Delaware law. This is Bloomberg. Elon Musk went to war with Delaware after a judge there shot down his massive Tesla pay package, and he moved his companies to Texas. Delaware is the corporate home to more than 2 million businesses, including more than 60% of Fortune 500 companies. Incorporation fees generate more than a fourth of the state's annual budget. So state legislators are proposing drastic changes to Delaware's business statutes following recent defections by companies moving their incorporation to Texas or Nevada in search of friendlier legal treatment. Joining me is business law professor Eric Talley of Columbia Law School. I mean, have there been that many defections of companies to Texas and Nevada that it's a real cause of concern in Delaware?
Well, thus far, the rate of defections has not been that much bigger than it has been in prior years. And in fact, there have been importations as well, defections to Delaware that have been going on at the same time. There are larger companies, right, that are more notable, particularly Tesla, that defected. And so in some ways that has cast a huge shadow over this debate. The numbers thus far, though, seem relatively modest compared to, at least by measurement against historical trends.
Is this all about Elon Musk?
Well, I think probably Elon Musk plays a big role in this story, right? That he is definitely, after having lost, at least at the trial level, his compensation case, he's been, kind of on the warpath against Delaware. And I think in some ways that has probably, caused a little bit of celebrity around the question of, where's the best state to incorporate? And that doesn't necessarily mean that when you start looking around, you're going to find choices that are, substantially better or easier to predict. But that probably did get this conversation started because a lot of what is being put behind the new proposed regulations is sort of a sense of there's an exigency that we really have to take care of right away. But thus far, the numbers don't really quite back that up, at least yet. That doesn't mean that it's not a cause of concern because, absolutely, Tesla is a big company. Mr. Musk is a very influential person. And so, it no doubt helped get some of the ball rolling, which probably on some level explains both the breadth of these new proposed changes and the fact that they didn't really take the usual course that various types of statutory reforms take in Delaware.
Looking at it as a whole, what's the most important or most significant change?
Well, they come from a bunch of different directions, but one of the things that probably unifies all of them is that these changes do not necessarily just sort of pick off one or two Delaware precedents. I was trying to count them up myself, and it's easily into the 30s, if not the 40s, in terms of the number of Delaware Supreme Court opinions that these changes would substantially roll back. Now, they are fairly sweeping, but probably the core of them relates to a provision in the Delaware Code that concerns conflicts of interest, right? Situations where there's a decision or a transaction made by a company that benefits either a corporate fiduciary or a big shareholder of the company. And there have been probably 5 or 6 sweeping changes. Probably the most important one over the last couple of years is to sort of lighten the pressure on controlling stockholders who really have gotten most of the scrutiny in recent years in Delaware, including in Mr. Musk's compensation case. And that change would essentially basically say for most types of transactions, we're not going to make it as hard for you to get essentially a hall pass and not be subject to liability for conflict of interest types of transactions involving a controller.
So then it basically alters the balance of power between minority shareholders and corporate leaders?
That seems to be the intended effect here. And, one can definitely debate about where that balance of power should be. And in fact, that's part of the discussion about, competition between states, right? They're essentially trying to turn up or turn down that dial on how much scrutiny they give, officers and directors and so forth. And Delaware had provided ways that even a controlling shareholder could escape scrutiny, but you kind of had to do it in the right way, and you had to get the appropriate votes and permissions, and it had to be set up from the very beginning. And the new statutory proposal makes it less necessary to set something up from the beginning and doesn't really require as many hoops to jump through. But the other thing that's kind of interesting, and I think when you talk to most practitioners and professors and judges, one of the things that has made Delaware special is that it's got a relatively large amount of case law and expert judges that you can make, pretty good predictions on how various cases are going to come out. And this is one of the potential problems, or at least a risk factor with these new statutes, is that a lot of that case law now is being overturned by statute. So it's kind of like, stars that you were kind of guiding your ship by at night, a large portion of them now have basically disappeared. So, and we don't have any track record of interpreting this new broad sweeping statute. And in addition, it sets up much more kind of formulaic rules that leave less to the discretion of the expert judiciary. So now one of the things that's going to be a little bit more complicated, it seems to me, if these proposed reforms go through, is not just the question of how much, where do you set the balance of preferences between minority shareholders and controlling shareholders, but the number of stars left to reckon by are much fewer, and the judge, if you want to liken that to the captain of the ship, doesn't have as many places that they're allowed to go. And so in some ways, I guess I have, some concerns that in, sort of trying to move really quickly to deal with this panic about Delaware exit that may or may not even be going on. Some of the biggest benefits of being incorporated in Delaware, the expert judiciary, the large stock of case law to guide yourself by, are now also being weakened. And so it's unclear that even if you like the idea of giving, controlling stockholders more authority or more freedom than they have historically had or had in the last couple of years, it is necessarily going to be the best move to also say, well, guess what? A lot of the precedents of Delaware now no longer count. We're going to have to start building them up from the ground up, or at least from, a lower level up. And, that quite frankly could give states other than Delaware an in to say, hey, look, if you no longer are depending on your expert judges as much as you used to, and if you don't have as many precedents to guide you as you did before these reforms, maybe this is a real time where a state could step in and say, we're going to start building up precedents ourselves. And I think, a lot of states, including Texas, including Nevada, and probably some other states as well, are starting to see this as a potential opening, even though the purported reason for it was to keep that from happening. And, I think you could make arguments in both directions, quite frankly.
And you wrote that this is a direct rebuke of the Delaware judiciary.
It's really hard to read it as anything other than that. And in fact, even the proponents of it have basically said, yeah, we really, really like Delaware law, but there's some opinions where Delaware has strayed onto the wrong path. And so, on some level, I think everyone, even the drafters and the proponents of this legislation, were basically doing this as a way to, box in a little bit, at least some judges that had authored opinions that at least certain people didn't agree with. One definitely can disagree from opinion to opinion. In fact, I do regularly. But the question then becomes, what's the best way to disagree with an opinion? In this case, this seems to be a fairly substantial reform to the Delaware Code that didn't even go through the proper channels. I'm not confident that it's actually going to accomplish what it's setting out to do, however.
It just strikes me as odd that you don't like the way that some decisions have been coming out, what you said, like 30, and so the legislature makes a wholesale change in the law?
Well, it definitely gives rise to a new form of instability that I think we're not used to. That, there were always people who would disagree with various outcomes of cases, and there was an appeals process to do that. In fact, it turns out that even Mr. Musk's case has not been decided on appeal. But rather than wait for that appeal to occur, the Delaware legislature essentially has gotten kicked into action by proponents who, obviously have their own goals in mind, but it's an odd way to respond to one or two cases by essentially, obscuring or nullifying, nearly 36 cases from the Delaware Supreme Court. And so, we'll see where that ends up going. The other thing that's kind of interesting about this particular proposed reform, June, is that over the years, Delaware had sort of set up a system where it first consulted what's known as a council, or a Delaware Corporate Bar Council, that essentially is made up of practitioners in the field on both sides, defense side, plaintiff side. And they kind of, try to hammer out some proposals that might make sense for the legislature to go after. And then those, the ones that kind of make the cut there often then get put into a bill that is introduced to the General Assembly. That's not how this one took shape, however. As far as I can tell, the council was minimally involved in deliberating these things. Essentially, they have now been asked to comment on the proposals that are already pre-baked, but they don't have obvious rights to redraft them or to say this is just a bad idea. I guess they could, but it's a kind of an odd inversion of the usual process that people are used to. And I think that's another reason that people are kind of wondering whether this might give maybe some short-term satisfaction to people who would like to see a couple of precedents changed. But it is almost certainly going to have some collateral damage, the size of which we don't really know.
And who drafted this legislation? Were there any heavy hitters?
The exact identity of the people has been not completely disclosed publicly. We do know that the law firm that has been representing Mr. Musk himself was doing a lot of the drafting. There are proposals inside it that certain former judges in Delaware had, been advocating for unsuccessfully through case law that ended up making it into the proposal. So one would presume that there was a role there as well. From what I know, the drafting was going sort of hot and heavy until the very last moment, and no one knew exactly what was going to be in these things until they were ultimately released. So it's not, exactly clear who all the players were. Some have come out and said, yes, I played a role in this, but we don't know exactly who was responsible for the drafting of specific provisions.
Coming up next, I'll continue this conversation with Professor Eric Talley of Columbia Law School, and we'll talk about whether there's been a backlash to this legislation and will it affect its passage. I've been talking to Columbia Law School professor Eric Talley about state legislators in Delaware proposing drastic changes to its business statutes following recent defections by Elon Musk companies and others moving their incorporation to Texas or Nevada in search of friendlier legal treatment. Since this legislation was revealed, has there been a backlash so that perhaps it will not pass?
Well, I think there has been a backlash. In some ways, people who have, long celebrated the idea that Delaware has become popular because it is predictable, because of the fact that expert judges are allowed to, to use their discretion and the statute is flexible, to, express some pretty profound worries about the possibility that these reforms are actually pushing against those longstanding benefits of Delaware law. There's also some at least potential argument out there that this could have some constitutional limitations on it as well, because after all, what we have in this situation is the Delaware Assembly, passing a statute that constrains the equitable power of the Delaware courts. Just like the federal constitution, the Delaware state constitution has a separation of powers aspect to it. And in particular, the Delaware Court of Chancery's ability to exercise equity, at least by some arguments, is something that's guaranteed in the Delaware Constitution. So should this go forward, I think there's not only going to be a continued debate about the process by which this bill came to the floor, but you might even see some constitutional challenges to whether it's even possible for the General Assembly to do what they're doing here without changing the Delaware Constitution.
These changes, how much of the questions that come before Delaware courts, how much does this represent? Is it like 50% of the questions that come up, 25?
It's a good question. In recent years, it's been a fairly regular occurrence for cases involving controller conflicts of interest to be in front of the Delaware courts. Now, that's in part because over the years, it became a little easier to figure out how to set up a transaction that has a conflict of interest, say, involving just an ordinary director and officer, that would keep it out of court. And these were the ones that were always the ones that got the most scrutiny and therefore the most challengeable. So it's certainly the case if you look into recent Delaware opinions, and there are, not only, the Tesla opinion with Mr. Musk's compensation, but another case called the Moelis case that involved controlling stockholder, and the Match Group case, which was a Delaware Supreme Court opinion from last year. These have been, some of the bigger opinions that are out there. A recent case that just came out involving TripAdvisor and its decision to reincorporate out of Delaware is also one of these controlling stockholder cases. So I think there is a real sense in which the controlling stockholder issue has definitely bubbled up in recent years to occupy a lot of people's attention. The way that the courts have dealt with a lot of those cases, sometimes they came out against the controlling stockholder, sometimes they came out in favor of the controlling stockholder, but a lot of them, basically said, look, Delaware law still is flexible enough to allow you to, set up your own, if you do it from the beginning and disclose it in a way that people will be able to understand and investors will be able to understand, you could set up a structure that gives a lot of control that's not very reviewable to a controller. And so the big move that's being made here is that the statute is saying, first, you're not going to be required to do it. The statute's now going to do it for you. And second, the way that it's currently drafted, you've got no choice, that there is no ability to contractually shape how much scrutiny your controlling stockholder gets. Delaware is now making this a one-size-fits-all type of legal test for evaluating those situations. And that's very peculiar because in a lot of other situations, very recently as well, Delaware has moved towards what people sometimes refer to as a more contractarian model, which says, here's the basic rules, but you can come up with your own you can tailor your own system to get around them if you want. And this, sort of most recent episode effectively moves in the opposite direction in terms of how much contractual freedom you have as well. So that's another reason to kind of, scratch your head a little bit about not just the content of the provisions, but the fact that they've been made, seemingly immutable. Seemingly they have to apply to everyone.
As far as Texas and Nevada, don't they have a long way to go before they reach the point of matching the expertise that the Delaware Chancery courts have?
Everything looks great when you haven't really dug deep into what the alternatives are. But, the Texas business courts are, we really don't know what we're going to expect from them. There are some things about the Texas business courts that give one a little bit of pause if what you're worried about is litigation that is hard to predict and costly. So, for example, the Texas business courts have jury trials, whereas the Delaware Chancery Court does not. So it's not really a matter of necessarily just convincing the judge, but you've got to sell your case to a bunch of lay people who may or may not be very fond of your controlling stockholder. There are interesting provisions in Texas law that allow you to actually order a deposition from someone before you even file the lawsuit, which I find kind of an interesting thing as well. And then the judges, it's almost baked in. They have a 2-year tenure. So, one of the things about the Delaware judges, not only are they kind of recruited as experts, but they have much longer terms and are allowed to essentially develop more expertise. My guess is it's going to take a good year to year and a half for any judge to get up to speed on some of the key cases that are going to be heard. And then, their term is almost up and they got to hand the case to the next judge in. And so a lot of these things, if you're under the impression that moving to Texas is going to be a nice, predictable, calm experience, it's not clear at all that that's the case. Nevada probably is further along than other states in at least developing a little bit of a jurisprudence, and they do have more permissive rules than Delaware. That's one of the ways that they have branded themselves. But even Nevada now has just introduced a constitutional amendment creating strict business law courts because while they had business law courts already, they were hearing other matters as well. And so the other states that are attempting to compete with Delaware haven't necessarily put forth a set of alternatives that is hugely predictable. It might be attractive to some companies, but for other companies, it's really, it's very, very early days and you're not going to know. And then the question is, do you want your company to be the canary in the coal mine, right? To try out some new state court or new state law outside of Delaware and see how it goes. I certainly would like to see other companies do that if I were making that decision. On the other hand, if in fact, the import and the effect of these new statutes is to kind of tie the hands of the Delaware judges and not allow them to use their expertise as much as they have before, and also to, eliminate existing precedent from the books so you have less to guide yourself by, maybe this is really an opportune moment to start, seriously trying to compete with Delaware.
Is there anything wrong with a little competition among the states to get companies to incorporate?
Competition isn't all bad. Delaware has definitely, had kind of a monopoly position here for a long time. And you would think that they would want to take moves that make that position more durable, and they have generally. But one can question whether these are going to do the trick or not. If it's the case that we get a little bit more of an open, competitive free-for-all among states, then you could see a kind of an interesting environment shaking down where states themselves, aren't trying to mimic each other, but are actually offering different points on the spectrum to sort of say, here's the kind of companies that we specialize in, or here's the balance that we strike here, and we're going to develop precedents around it. And then you might see companies sorting in a much more varied way amongst these different jurisdictions. And in some ways, that type of competition is, probably going to be helpful for, trying to find the right law to fit you. But it's also a painful growth process because we don't have a lot of existing precedents to make any predictions about these other states yet. That's going to take some time. Delaware, at least up to now, has been a more predictable place. And then I'll just add one other thing, June, that, I probably am personally responsible for, cranking out maybe 12,000 corporate lawyers who are practicing today. And they all specialize in Delaware law. They don't really know much more than Delaware law because that's mainly what we teach them in law school. So, my job is going to change as well. And then I'm going to have to start teaching more of a general type of law. And I think if you are a practicing attorney in this area, if you're brand new, this is not a bad moment because you're going to know pretty much just as much as a senior partner does about, Tennessee law or Texas law or North Dakota law. If you're a seasoned partner who's been, whose stock and trade is, I am your person who knows everything Delaware, this is going to be a more challenging moment that you're going to have to, in some ways, go back to school to try to learn some of these other areas of law and hope that the precedents evolve in a way that makes it at least somewhat predictable. So it will be an interesting moment in time, not just for controllers or for companies, but also for lawyers themselves who have, by and large, predominantly developed expertise in Delaware law, and their own courts over the years have, even cited Delaware precedents as kind of the bellwether of how to treat other states' laws. And if that changes, then that whole ecosystem is going to have to adapt as well.
Veteran corporate lawyers will have to go back to the books. Thanks so much, Eric. That's Professor Eric Talley of Columbia Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.